what are your remedies? We talked about going to court, we talked about remedies under OPMA. You have remedies under the Meetings Act, but the remedies under the Meetings Act aren't as good. And they aren't as good for a number of reasons. First of all, talk about you have the GRC. You can file a complaint with the GRC, it's free, you can email it in, there's no statute of limitations, there's no GRC for the Meetings Act. If you have a Meetings Act violation, you have to go to court, and you have to go to court in 45 days. So when you're dealing with Meetings Act violations, you're on a very tough timeline. Okay, so what are the challenges you face? And guys, one of the reasons why minutes tend to be bad is because there aren't a lot of Meetings Act cases. There aren't a lot of challenges. So the clerks and everyone who's been doing these meetings, they've been allowed to get away with it because no one challenges them. The reason why no one challenges them is because there's no fee shifting under the Meetings Act. What does that mean? If you want to bring a case, you have to do it yourself, which I would not recommend, or you have to hire an attorney out of pocket, which, even though I'm an attorney, I wouldn't necessarily recommend because it can, the cost model doesn't always make sense for Meetings Act cases, or you find someone to do it for free. Which rarely you can. Like, I think if you bring the ACLU a sufficiently egregious Meetings Act violation, they might help you. So there's no fee shifting, so you don't have a lot of cases. In addition, you have to bring your case within 45 days. And in sort of the situation we're discussing, let's say you have these meeting minutes, that are these one-liners, maybe even like 2 words. Well, you have to bring that action within 45 days. And then
the minutes being produced, or a meeting, or
when you became aware of the violation. So there's a little bit of play there. However, to get a remedy, you have to show repeated violations. And that's an unfortunate case. It's called McGovern v. Rutgers. McGovern was a Rutgers University professor, pro se, although once the case got into the upper levels of court, ACLU and others were filing friend of court briefs. And Rutgers, I forget exactly what Rutgers was doing, but Rutgers was making several technical violations of the Meetings Act. And McGovern wanted a remedy. And the Supreme Court said, look, unless you can show multiple violations of the Meetings Act, you're not entitled to a remedy. And the other problem is they can fix the problem. So let's say you come in and you ask for copies of the meeting minutes, and you say these minutes are junk. You file your lawsuit, you spend your $300 on your filing fee, God forbid you hire an attorney, you're paying an attorney, you're in court, you file your case, you serve your complaint, and then if I'm representing the other side, the first thing I'm going to do is I'm going to turn to my client and say, look, you've been sued under the Meetings Act because you have bad minutes. At your next meeting, rewrite the minutes and make them better, and then as soon as you pass better minutes, you send those better minutes to the attorney for the other side, and you say, hey, we fixed the problem, guys, so dismiss your lawsuit. And the judge might actually go for that. So that's another one of the reasons why the Meetings Act has very little teeth. Someone comes to me and says, well, Walter, we'll pay you to sue. I'll say, look, you can pay me to sue, but there's a good chance that as soon as we sue, whatever they can fix, they will fix. And then, what have we done? We're not going to get a court order because the judge is going to say, well, there's nothing left for me to do. I fixed it. So what does that leave you with? What's a successful Meetings Act case look like? Repeated violations, preferably going on for months or years. That's what I look for. I've had successful Meetings Act cases in the post-McGovern era. It's been like 3 years. You have to do your research. You have to find multiple violations. What are some examples? I'll give you my 2 most recent successful cases. LoPACON. LoPACON did not have executive session meeting minutes for years. Literally 3 years. They just didn't do them. Okay. Well, we got an order and we won that case. We got an order where the judge said, Just put them together, reconstruct them, do the best you can, reconstruct the minutes going back 3 years, and give the other side whatever you got. Another case that we just won, this was actually last week, where again, the public agency, no meeting minutes for 7 meetings going back like 5 or 6 years. This didn't happen. So in that case, the judge actually granted injunctive relief, which is more than a court order. The judge said, look, don't violate the law again. And that's a standing order. So for this particular, this is actually fire district. For this particular fire district, that standing order is in place. It's called an injunction. 2 years from now, they violate the order. We can go back to court and ask for sanctions against them because they violated a court order. So not only that, in that particular town, they not only have to follow the Meetings Act, but if they violate the Meetings Act, they could be literally subject to contempt of court because the judge said, look, you know, you screwed up so badly that now I'm going to order you to follow the law and have to answer to me if you break it. Man, I'm sorry, you got a question?
I was just going to ask, does the judge need to request the past records? Because I know you said something about 45 days. Does the judge have to put that order for the past records, or can you OPRA that because you want to prove that this has been going on?
You're exactly right. The question is, you know, how do you prove your case?
Yes.
It's on you to prove your case to make those OPRA requests.
Okay.
In the 2 cases that we had, I forget, either the clients came to me having done all their homework, or we just, whatever gaps there were, we filled them. Yes, you go back as many years as you can. I had a case, this was Rockaway. You know, Rockaway, I don't think that they had done executive session minutes from 2012 to ever. So like recent ones they did, but old ones that they couldn't construct, I mean, they might have had like 12 years, no minutes. So we got the relief in that case.